coming up next.
The limitations of a living trust and instructions to a living trust is limited to the imagination of the instructions you're willing to write.
That's amazing. Now,
Right?
who would carry that out, though? How
Okay,
would that
there
be
is an
carried out?
executor. I'll give you an example. She had two people. She had one which was one of the neighbor's daughters, and then one a lady from church, and the third person was would if those people were no longer here, the third person was a corporation, and the corporation there's corporations like, for example, U.S. Bank. It took us a while to find one, but now I know US Bank now has a department that manages living trust. That's their sole department that and they have been doing that for years and years. And so they manage it. They charge a small management fee, but if you know if it's to protect your children from themselves, I think that that's just the cost of doing business, right? The cost of being able to make your wishes.
Welcome to Faith Over Addiction podcast, where the chains of fixing and striving are broken and joy is rediscovered in Christ. You are here because you know there's more for you, a life beyond addiction's chaos, rooted in God's peace and promises. This is the place where Christian women like you learn to release the weight of fixing and striving and instead lean into God's strength to create a home filled with love, grace, and hope. She is clothed with strength and dignity. Proverbs 31:25. That's you. You may not feel like it yet, but you are stronger than you know. And God has so much more for you than carrying someone else's addiction. Here, we'll uncover how to set healthy boundaries with love and a little humor. Find resilience and grace in the messy moments of life. Celebrate small victories and embrace joy like never before. Lean into God's promises for restoration and strength because He's not done with your story or your loved ones. This is your invitation to rise up, embrace your worth in God's kingdom, and take back what's been stolen by addiction, your peace, your joy, your future. Your faith is the foundation and your boundaries are the bridge, and God's truth is your guide. I'm Tanya Gioia, your host and fellow traveler on this journey through the chaos of addiction. I'm here to cheer you on, equip you with tools that work, and share the truth that's changed my life. The joy of the Lord is your strength. Nehemiah 8:10. Together, we'll uncover how to create safe, loving space for healing, starting with your own heart and home. By setting boundaries, trusting God's plan, and embracing His truth, you can reclaim your joy, your peace, and your family's future. Then you will be able to stand firm for your family and legacy as a kingdom daughter. A woman who can laugh at the days to come, knowing her identity is secure in Christ. So grab a cup of coffee or tea and get comfortable. Let's walk this journey together. We're about to take back what's been stolen, create a safe, healing space for you and your family, and rediscover the joy God has waiting for you. Welcome to Faith Over Addiction, where we're helping women find their identity in Christ so they can be a safe and loving space for those they are empowering to leave addiction and join them in the world, being active citizens and serving God. And I have brought in Oscar Vasquez. We're going to talk about estate planning, wills, setting up some healthcare things that you might not have thought of. Now, this may seem a little off topic for us, but Oscar's going to talk us through why this is so important. And what I've watched is a lot of women are in such crisis mode that even getting to the doctor is a problem, that estate planning, their long-term care for their children is not something that they're thinking about. And then suddenly they get left with a divorce or there's a death and they don't have any idea of what's going on. So, Oscar, you were just talking to me about estate planning. We need the basics. What is it? What does it look like and who is it for?
Okay, great. Well, first of all, I want to say thank you. Thank you for allowing me to come on your podcast and helping me on my crusade to bring awareness to estate planning to clear up a lot of the misconceptions that are out there in the world today. Thank you for that.
Awesome. Really appreciate you having here. And I know we're going to learn a lot today.
Yeah, so today is definitely grab a pen and paper because I'm going to give you a lot of nuggets. But I want to start off with having you understand what an estate plan is, and it's also known as it's a slew of end of life documents or living documents. One, however, the pillar of it is called a living trust, and a living trust is basically the agreement between the parents or a trustee and the beneficiaries and their kids, which are usually their kids or organizations, whoever they want them to benefit from their assets. That the courts help to enforce that agreement. So, with that said, that means that every living trust are not all created equal depending on on how many legal provisions you have, but all the legal provisions in a living trust are the same, and the only thing that is different are the grantors and the beneficiaries and the instructions you leave your kids, because the agreement is basically the instructions on what you want to have happen.
Mm-hmm.
So, knowing with that said, that means, in a nutshell, an attorney does not have to draw up the agreement to have it a comprehensive living trust, because we are a software company. Estate.prep.com is a software company that makes living trust affordable to the masses. We are the only probably estate planning company that it comes close to what an attorney can do as far as comprehensive and how much instruction you can literally give. First of all.
Okay. So before my audience begins to shut down because they're in financial crisis, you do not have to be wealthy to do this. And that's one of the things that your company makes possible. Why would they want to do it?
Well, that's one of the misconceptions that most people have, right? Because they think that, it, because it used to be, the trust fund babies, and this is what it takes, and you had to be wealthy or you had to come from generational wealth or have that. Well, I'm here to tell you that everybody has an estate, and every state has a minimum threshold to go to probate. I'll give you an example. Indiana, if you have an assets more than $50,000, in other words, you own a mobile home or a house or anything in Indiana that exceeds 50,000, you have to go to probate. That means if you're a homeowner in almost any state of the land, you're gonna forepass the threshold of going to probate. That's the first thing. The second thing, you don't have to have millions and millions of dollars to be able to create a estate plan. What matters is because an estate plan is one, it saves you on many things like taxes. It'll save you on taxes. It'll save you on home care. It'll save you on, like, even having if you're a homeowner, it's almost imperative that you have a living trust. But more importantly, it does not only saves you in the taxes and headaches, but it leaves instructions for your child to be able to follow and be able to have control of it, of the assets. Like, for example, your home, right? I'll give you an example. I think, the people who are like, well, how do you, if you can't give legal advice, how do you do it? And I said, well, what we do is we share stories of the hundreds and hundreds of cases that we've helped families, and we work with a lot with educators and police departments to be able to help them with their retirement, because most people don't realize that a living trust, all the protection that it provides and how it works to be able to transfer the little things that we do have, because everybody has an estate. Everybody owns something. And people go like, well, in a layman's terms, what is an estate? And I said, an estate is everything you can't take with you.
Which is everything.
Yeah, which is everything,
Which is
right?
absolutely everything.
And
Yeah.
that includes, like, for example, we started adding on about a couple years ago, we started adding Facebook accounts where people are leaving access to their Facebook accounts or their social media accounts in their estate plan. So that way when they pass, their kids can get all the memories that they had and their history from their Facebook.
I
And
hadn't
that,
even thought about that. And they
yeah.
can shut them down. If they want to shut them down, they can shut them down.
Yes, they can do that, but I think first what they do is, like, you can leave that special instruction. I want you to shut it down, but you can export anything and take anything you want with you, and then the rest I want you to shut it down or let it live, right? It's up to you.
That's awesome because we don't keep I mean, my babies are 17 and 19. I haven't really kept a photo album of them since they were like 5. It's all on Facebook.
Yeah. So and then not just the memory, but the check-ins when you check in, like,
Mhm.
hey, I remember that, or like we went to this place and I remember, I mean, I had one of our clients would say, you know what, that was probably, I never thought that mom took all these pictures of when we went out and when we were kids. It's amazing how that's what they use to build up the memorial videos, everything on her Facebook, which
That's awesome. I
that
never
is
thought
just
about it.
that was, to me, that was like, wow, that's, I mean, and that's when people started doing that. And it really became popular when Facebook said nobody gets access to your account. And it's nobody gets it. But if you leave it in your estate plan, it becomes a legal document that they have to give that to you because you're no longer here. Right.
Wow.
So
Wow.
that in itself is an ass. I mean, you don't need an estate plan to do that. You can do that by just having a legal document, statement, have it signed in front of you. Could just do that one document. However, it's all included in your estate plan if you create one.
Mm.
But Facebook won't release it. And I say Facebook because every one of us has that now. I think, except our kids. I think most of our kids are Instagrammers now, but they don't
they've
like
they've
Facebook.
moved on.
Yeah, they're like Facebook's for old people deal. And I'm
That's right. Well,
great.
what
Okay.
so your estate planning, so so my mom passed 4 years ago.
Mhm.
My parents had a living trust. So that transference was completely smooth. There was no question. There wasn't frustration. Title of the house passed just immediately to him. It was, of all the things we had to do, because when there's a death in the family, there are a lot of things you have to do if you
Yeah.
haven't been through it. Of all the things we have to do, that was made it really, really simple. I probably spent for 3 weeks, maybe 5 to 10 hours a week working on, closing some of her accounts and making sure that the SSI went over here or that this went over there. But the assets that they had, like the house, the stocks, the bonds, the cars, all those things were simple. Explain why that was so simple with the living trust.
Because the living trust there's the offer word is this. So I always tell people this. Google is the a living trust is the only document that has the transfer of assets when death that doesn't allow the government to get involved.
Yeah, we had
And
no government questions
no,
whatsoever.
it's private. It's private. So let me tell you what happens. And if you don't have a living trust, you have to go to probate. And so the first thing that happens at probate and I'm going to use California because this is where we sell a lot of real estate in California. And that's how I got involved in estate planning. I've
Mm.
been in real estate for 28 years. And at 15 years in, clients started to get older and they started to pass, they started to go to probate. And I said, well, how do I prevent this? So I said, I'm going to start educating my clients on how this is going to happen. And the first thing that happens is you have to find an attorney to file probate in California, and it's going to run you anywhere. It's about 6 to 8%. So everything in California, if you own a house, is worth about $1 million. So that
Mm.
means $80,000 that your beneficiaries will lose, right?
Mm-hmm.
If you own a mobile home in California, it's still 250,000, right?
Mm-hmm.
But it's still a home. It's still an asset. It still has something of value. So what happens then is then the attorney files for you, or he says, you know what, Oscar, instead of you paying me the 80,000, I'll wait until you liquidate the house, right? Or they may be forced to liquidate the house, or we'd be able to do that. Now, when my clients that did not, they procrastinated, they said tomorrow we'll do it, right?
Mm.
um those people, we always talk to their kids, and we always say ask them for a 7 month contingency after you get title to refinance to be able to pay them, because nobody wants to, if they living in the house, because in our Hispanic community we share the home.
Mm-hmm.
We are, we have, there's a lot of us. There's a,
It's
right.
generation. It's the multi-generational, which is we're finding is so beneficial. My father lives with us 6 months out of the year, so we've got a
Right.
multi-generational house. Yeah.
Yeah. So what happens is they don't want to sell the house because that's where they live. So we always talk to them about asking the attorney. So that's the first thing. The second thing that happens in probate is that they publish your assets. Now,
Oh.
not only do they tell people what you have, but the biggest concern when it gets published is that it opens up to the world of scammers, because
Oh.
they could file what the publication says. So and so died. They had this many assets. This is their property address. This is when they died. These are all their assets. If you feel they owe you money,
Oh.
or if you feel that you're a descendant of them and feel that you should be a benefactor, please come forward to the hearing or
Ouch.
file. Yes.
We didn't do any of that.
No,
None of it.
because a living trust prevents probate altogether. So you saved $80,000. You didn't have to have all your mom's business published, right?
No.
The second thing, the third thing that happens is after they come forward, then the judge decides on what happens to your things.
So it's out of my. I worked for the court system. It's out of my control. The
That is
judge can
correct.
put. It's public. It's out of my control, and I am left with whatever the judge deems is mine.
You and sometimes, and I'll tell you, the biggest scam that I've seen was, and it's only been like 2 or 3 cases where somebody filed a $3,500 claim, $3,500 claim, and the attorney said it's going to cost you 5,000 to fight that. And they called me and they said, "What do you think?" I said, "Listen, that's putting bad money after good money. Just, you know what, count it as a loss, and you just got to roll with it. There's no way to spend an extra $1,500 to fight it because you already have a small margin left." Right?
Mm-hmm.
That's going to be eaten into your inheritance. And if this guy's self-published and or self-represented himself, he's going to fight the attorney, and that 5,000 could be 7, 8, $9,000 to fight a $3,500 claim. Just write it off. Tell him you're going to pay him and move on. When it's that slow, that's the probably the hardest part to have to tell somebody that just lost their mother or their father, or the last one. So that's what then the judge decides. Now, judges are human like everybody else,
Yeah.
but they have a caseload of this many cases. Okay, who's here? Who's the descendants? Who's the kids? Great, equal shares, go to waste. I've never seen a judge disinherit somebody
Mm-hmm.
that was named. However, if the kids don't name everybody or forget that long lost, or that brother that never comes to Christmas, never called mom, or that one person, he can get disinherited by accident, right?
Okay.
And because there's no record of it, it's only what the siblings say. Yes, this is who we are, and they always do that. Now, I did see one case where the gentleman left the family in Texas. He came in, built out something really well, and he had a will, and he goes, no, the will would do it. He still had to go to probate, and they published it. The kids and the ex-wife came from Texas, and they got, instead of the kids getting 25% apiece, they ended up getting 1/7 because the judge awarded the other three kids. And that was something that they, during the divorce, he paid out a settlement to for
Mm.
those kids when they were younger, to kind of leave them something, but mom mismanaged money, and now they're collecting, and the judge gave them the money. In other words, they lost a portion of their disinheritance because they didn't have a living trust. If they would
So
have had a living trust, that would
explain
have been provided.
explain the will versus the living trust.
Okay, I'm gonna give you the shortest version and the most layman simple terms. A will is usually 2 pages long that says, I love you, I leave you everything. Still has to go to probate. A living trust is about 140 pages long, that is private, and it prevents you from going to court.
Which we would all, if you've never been to court, judges are human. They do the best they can. But as you said, they have a huge caseload and they're moving through the caseload. Your case is not unique. They've seen 10 of it that morning. So if you expect to go in and plead your case without a very high powered attorney, you're expecting the wrong thing. You will get more of what you want if you do this privately
Yes,
without sharing this with the public. So when you're talking about a living trust, what would people need to do to begin that process?
yeah.
Every one of us has an estate. We all have things that we want.
Right. And I'm going to dive a little bit deeper into the provisions of a living trust. What are the things that you can do with the living trust?
Very good.
Because and I'll give you an example. One of the things that we've had an educator do, that I thought at first glance, like, wow, why would you do that? And then after she explained it to me, um, she wanted her son, as an adult child. She wanted the house liquidated, and then she wanted the money held in trust, and then to be dispersed on a monthly basis according to the per capita of, or whatever the average income was. That's how much she wanted him to have, so he
Mm.
could be set for there. But she wanted him to take a hair particle test and a drug test, and an alcohol test 2 days before, or whatever the minimum requirement was to be able to provide that test, before he got disbursement, because she was determined. He was already sober 22 years.
Mm-hmm.
Um, however, but she said that her journey to getting him sober was one of the hardest things that she had to do.
Mm-hmm.
And it was she said, this addiction, Oscar, it's a disease that takes control over the human mind and body like you can't even imagine. I said, I can't. And because I asked her, I said, why, Mrs. Sharon? Why is that? She says, you know what? I'm determined as his mother, whether I'm dead or alive, to make sure that he is going to stay sober. And
Wow.
if he's gonna be using, if he falls, right? If he falls, like, he's going to church, he's Christian, he's very involved. You know, and she said, I would probably remove that provision if he got married to a Christian girl. And I said,
So
okay.
she was doing accountability, but she was also saying, I'm not going to enable this behavior, because we know, having experienced death, that can be a real low point, a real grief point, that you can reach for those numbing agents. And she, no, if
Yeah,
you
she's
reach for
like,
those
no, she
numbing
said, you know
agents,
what?
the money
He
stops.
will always be my son, and he's not going to use my money to kill himself, and it's going to go there. And then she made sure that if he did have kids, and she made sure that his child had a little bit left over for when if he wanted to go to school or whatever, but
Right.
he wanted to make sure she said he if he has his father's genes, want to make sure that doesn't happen either. So wanted to make that. So I wanted to share that provision because the limitations of a living trust and instructions to a living trust is limited to the imagination of the instructions you're willing to write,
That's amazing. Now,
right?
who would carry that out though? How
Okay,
would that be
there is
carried
an
out?
executor. I'll give you an example. She didn't. She had two people. She had one which was one of the neighbor's daughters, and then one a lady from church, and the third person was what if those people were no longer here. The third person was a corporation, and the corporation there's corporations like for example U.S. Bank. It took us a while to find one, but now I know US Bank now has a department that manages living trust. That's their sole department that and they have been doing that for years and years. And
Mhm.
so they manage it. They charge a small management fee, but if you know if it's to protect your children from themselves, I think that that's just the cost of doing business, right? The
Mhm.
cost of being able to make your wishes. So that's how she set up her provision. She wanted them and then the church, and then she wanted that, and then obviously she still gave a tie-in to the church where she wanted to make sure the church was always there. She was very she's still alive now, but I wanted to share that provision, and I wanted people to know that that one living trust. Now, before we get into that, I want to tell you about. There's 19 different documents that you can create in a comprehensive living trust. They're not all pertinent, but there's three documents that are super pertinent, and you could use these for your children. And I
Mhm.
think that you use those for your children. I'll give you an example. If your child turns 18, they are now a legal adult, and
Mm.
that means that they have the rights to privacy of medical conditions, and they
Yes.
have the right to privacy in medical records. And that means if you have a HIPAA waiver that allows you to get copies of their medical records if they become incapacitated. Now, the
Mm.
medical records say it says you could I give authorization to Tanya or to Oscar or to X if I become incapacitated for the well being. That's the first record that you should have for your kids because as a mom, you want to know what's wrong with them. And
Right.
if you want a second opinion, you're never going to get a doctor to go come across country to come and see the records.
Mhm.
However, you can always send them to them if they're a specialist from across the country, if you
Mhm.
have a HIPAA waiver. The second one is a healthcare directive. A healthcare directive, meaning if they're an adult and this comes with your estate plan, but you can get one for your child as them if they once they become an adult, you would say that means that he gives you rights to be able to make medical decisions for him if he becomes incapacitated.
Yes. Which is what happened with my mom, and we had medical directives. We knew what she wanted. What we didn't know, and I hope people listening listen to this, is the non-resuscitate, at least at that time, did not include the intubation tube. And she was intubated before we had a choice about that, which meant the doctors and the emergency folks were doing their job. But we had the really hard decision of whether to pull that or not, which, had there been the living trust set up in a way that we understood that non-resuscitate also included into or put that clause in there, we wouldn't have
Right.
had that problem. So there is a lot to think about, that when you get into a medical system, you don't know the terms, you don't know the jargon. If you
Yeah.
have been healthy most of the time, and I must say, we had a great team of doctors and we worked through it. But man, there were some decisions that would not have had to have been made had that living trust included some other pieces that we didn't.
Yeah, and I think that that's, that's the human, and I call that, like, people always say, how long does it take to create a living trust? I said, if you have all the answers to the questions, it'll take you about 45 minutes to an hour. However, there is a human element that, because there's questions that come up that lead to more questions that you never thought about, and sometimes you've never thought about, and you talk to it with your spouse, and what do I really want to, I always say this is part of the human element. Go pray on it, think to the higher power, do whatever your beliefs are. But this is a document that can be changed at any time, because a revocable living trust can be changed and updated. But at the very least, if you happen to if something were to happen to you tomorrow, at the very least, today that you thought it through of what you really want to have happen, and take
Yes.
that human element, that time to say, hey, I want this to happen. And this is what the way I want it. The end of life is probably one of the difficult parts, that they say, I want to talk to my kids about this. I want to, yes, there is no hurry. You have access to our living trust software for the rest of your life. You pay a one-time fee, and you can make as many changes while you're alive, unlimited. Where a real estate, an estate attorney charges you what's called a restatement fee. They charge you to change it, and that can be anywhere from $1,200 to $1,800. And then the average cost to create a living trust, the national average, is $4,000 now. I mean, a year and a half ago was 3,000. Now it's 4,000. Like everything else in the world, right?
Yeah.
I mean, I went to Carl's Jr. about 3 weeks ago, and it was $22 for a famous star for onion rings and a Coke. I'm like, no, no, no. I just wanted lunch in a bag. And they're like,
yeah. I agree. I just went to we live in a small town, but I just went to one of my favorite restaurants, that was pretty reasonable, $15, $16 for catfish platter and hush puppies and all those things. It had gone up by $5.
Yeah.
Now, I realize that because some of the things they do involve eggs, which are what, $16 a dozen, all those types of things. My input for that is, we have a will, but we need to do some changes to that will. We did it with a friend of a friend's attorney. We didn't pay very much for it, but that was almost 20 years ago. Now we've got coming in complete adults with our children. We need to do some changes to it. We're going to have to go back and pay that money. Same thing happening with my father, who lost his spouse 4 years ago. He needs to make some changes. His attorney has passed away, so he has to go find a new attorney. Whereas with your software, I imagine you can just get in and go, I want to change this, because the changes are minute.
Yes, yes. And that's because what happens though, a living trust, there's no such thing as an amendment. It has to be a restatement. It has to go on top of it, because it says everything that was dated February, or the changes that are changed from the trust dated February 2025 in 2026, this is what I want to have happen now. And I change that, because what's supposed to happen when you pass is the person or your executor is supposed to give all their siblings or all the beneficiaries a copy of the trust. And most people don't do that. They just say, mom didn't want to leave you nothing, or this is what they happen, right? Or, you know what? I mean, but you're supposed to leave it, and you have that right because you're the beneficiary. Anybody that's named, that's the thing. So our software, unlimited changes for the rest of your life. There is every year after the first time that you get it, it's $129, but because that covers every state has legal provisions that change. So we cover that cost together as all users, to cover that cost to pay for the attorney to update it on an annual basis or as needed basis. So that beats that $1,200 or $1,900. So it becomes very affordable. The second thing is the unlimited access and unlimited provisions. You can print them and get them signed. There's three things that have to happen for a living trust to be alive. One, it needs to be signed in front of a notary. Two, it needs to be signed in front of two witnesses, so that way it's signed beyond reasonable doubt. So if anybody challenges it, the court sees it and it kicks it back and says no case because they have a living trust. You get what you get, buddy. What's on the trust is what you get. There's no changes. Nobody can make changes to the living trust because, and the third thing, it has to be funded. Now, an attorney does not fund the assets. He gives you a 9-page document and says, here's the instructions to protect your assets. Go follow them and do it. We do that because we also have a financial services company that helps you with that. So it's free, but we always find there's always things in there like I call it lazy money because we have a department that has a index annuities where they have zero loss money and they all have all the gain, no downside for safe retirement accounts. And most people don't do that. So we, as part of the service, as an additional service, as estate planning coordinators, that we go that extra mile. Not only, I mean, we do it because we want you to be able to have a funded case, but when we started to realize that attorneys, 98% of them don't provide that. They give you instructions and then you go like, well, what do I do? If there's nothing in the trust protects nothing. So it has to be funded and it has to be saved and sheltered from there. So it's really, really important that you understand that it needs to be funded and the assets need to be transferred because you own nothing but control everything when it comes to your assets. That means you make all the final decisions, you could spend the money, you write the checks. The only difference on your checks is that it says, the Tanya Living Trust or the Tanya and Joe Living Trust, and here it is, or the Garcia, Gloria, whatever trust you name it, it has it on the checks. That's all it is, right? That's something that those are the three things that you need, and it doesn't happen. How do you get a living trust? It's simple, right? I want to give you a couple gifts. The first gift is I want to give you a phone number. It's artificial intelligence. Her name is Lisa, but she works every day, and she answers any questions and can talk to you about anything that has to do with estate planning.
So you can call her and ask anything. This is a free service.
It's free service. She doesn't try to sell you, but at the end, she will ask you, do you want to speak to a human? Or do you want to speak, or do you want to book an appointment? And the phone number is 805-909-4689. And I have to look it up because I don't have it memorized yet. We just started this. So 805-909-4689. The second document or the second gift I like to give you is the gift of a comprehensive estate planning guide. And the reason why this helps you with the human element of delay, because all those questions are on there that you should really think about and think about, who do I want to do this and what do I want to have happen? And you can get that at estate.prep/guide. This guide is free. You download it. I recommend you print it and you carry it with you until you can complete it. Full disclosure, just because you complete it doesn't mean you have a living trust. Okay.
But you've answered the questions that would take you to the living trust. You've answered what you'll need.
That would take you through that delay, and you could sit down in like 25, 30 minutes, 45 minutes tops, and be able to fill that in. And the third thing is that we have a discount code for the first 10 people that would like that on the lifetime value, unlimited updates and everything. We have a discount code, C-Woman. C-Woman is the discount code, and you will save $1,000 on the lifetime value of an estate plan. Now, the average
Awesome.
estate plan is $4,000 a year, or $4,000. You will be able, with this code, discount code, you will get it for $14.95, all in, and you unlimited updates, unlimited changes. And when people go like, when do I need the changes? And I'll give you an example. If your daughter or son, if your daughter or if your child, if you're a homeowner, you have an asset. You need
Mm.
it. This is not something you need to think about. If you don't have it, then you may not need an estate plan. But if you're a homeowner, you need to have it. But one of the biggest things that you want to have happen is that you want to exclude the spouse, your child's spouse, and have it go to their grandkids if in
Mm.
case your child passes before you. And I had one case, and that's when we added that provision in the first questions. We don't even you don't have to do that anymore with ours because we ask it during the initial interview. If this happens, what do you want to have happen? So we had that interview on there. Um, and the reason why we had that is because we had a case where we had a client, their mom and daughter took off to Puerto Vallarta, got in a car accident, they passed. The husband called me and said, "Hey, Oscar, can you log in for me and make that provision and print it out, and then so I can get it signed? But I want to go to Texas and see my sister because she's not doing well." Well, he never made it back. And the son-in-law ended up with his with his daughter's inheritance. I mean, I'm hoping they're his kids, right? So I'm hoping that he left something for his kids, but it was a very, very large nest egg from his retirement account and the real estate that he left. And he only had two children, a son and a daughter, and he wanted to make sure that the kids got all of it and they until they were older, and he got some to be able to live and to mourn his daughter and all that, but he wanted to make sure that they did that. That never came to fruition because he passed and there was no
Mm.
changes. I say that because you never know, but those are things that happen in real life that we don't know what the plan is. So with that said, I mean, those are the things that you have it. And I leave you with this. An estate plan is something that we have to have if we are a homeowner. But yesterday it's too late to do because yesterday will never be back. Tomorrow's not promised. Today is the best day.
Absolutely. Thank you so much, Oscar. Can you give us the website again of where we can find more information?
Yes, estatedoc.prep.com. And I will send you the links and the code so that way you can post them. And that way the first 10 people, in case they want to, by the time this airs, they'll be able to have access to that.
Awesome. And remember, folks, everybody has an estate. This is also about health planning. That's one of the biggest fears in the addiction world is somebody could die. This will give you a peace of mind of what's happening, or you will have access to these HEPA forms if you take action now. So like Oscar says, tomorrow's not promised. And with the death of my mom, it happened. She fell, and within 12 days, we had lost her. So nobody knew that this was going to happen. I really appreciate your time, Oscar. Thank you for being here.
Thank you for having me. Bye-bye.
Thanks so much for tuning into the Faith Over Addiction podcast. Remember, nothing changes until something changes. Today is your day to step out in faith and make a difference. You are a daughter of the King, a woman who can spark incredible ripple effects of hope and healing, not just in your own life, but in your family, your community, and God's kingdom. If this episode encouraged you, bless someone else by sharing it. Send it to a friend who needs a little hope, or post it on Instagram and tag me. I'd love to hear what resonated most with you. And hey, if you're ready to reclaim your God-given identity and create a safe, loving space for yourself and those you care about, let's talk. Book a quick call with me today, and I'd love to hear your story and help you take the next step. Oh, and don't forget to head over to Apple Podcasts Search for Faith Over Addiction and leave me a review. Your feedback not only makes my day, but helps other women find this podcast and step into freedom too. You are strong, you are loved, and the joy of the Lord is your strength. Nehemiah 8:10. Until next time, keep walking boldly into the life God has for you.